Hi folks, this is Jason Grace with McGuire Woods. We want to thank everyone for taking time out of their busy schedule today to attend the webinar discussing investments in the Cath lab and OBL setting. Investment in this area have become a very hot topic as CMS, both through reimbursement and policy changes, continues to encourage the healthcare delivery system to provide care in the lowest acuity setting where services may be safely provided. We're seeing a lot of growth in OBL and hybrid model development as a result of these trends, and today's discussion will cover a wide range of topics and provide an overview of the quote-unquote how to do or how to set up an OBL or hybrid, while also touching on some traps for the unwary. Depending upon the time, we're going to try and take some questions at the end of the presentation, but if we run out of time, please feel free to follow up with any of us with any questions that you may have. Since we have a lot of ground to cover, I'd like to quickly introduce the speakers. First off is Mark Toth. Mark's the CEO of ACA Cardiovascular, which is a firm specializing in the development and management of ambulatory cardiovascular centers. ACA is focused on vascular and cardiovascular specialties, and Mark's team has expertise in the conversion of OBLs to Medicare-certified ASCs as well. With a tenured team of both OBLs and ASC professionals, ACA has experience with joint ventures, Medicare certification, and managed care contracting. Mark has had articles published in Cardiac Interventions Today, Becker's ASC Review, Cath Lab Digest, MedAxiom Daily News, and Nephrology News and Issues. I'd also like to briefly introduce myself and my colleagues Jake Seelick and Tim Fry. All three of us are corporate healthcare attorneys with McGuire Woods in Chicago. Between the three of us, we have a very significant amount of experience setting up cath labs, OBLs, and ASCs in compliance with federal and state laws. McGuire Woods is an international law firm with over 1,000 attorneys and has the nation's sixth largest healthcare practice with healthcare attorneys located throughout the country. We were also named last year as Law Firm of the Year by Mergers and Acquisitions Mid-Market and M&A Awards. So with that, here are the brief learning objectives of what we hope to accomplish today. The presentation will provide an overview of the following aspects of setting up an OBL or a hybrid model with a particular focus on business issues and legal structures critical to setting up an office-based cardiac program. With that, I'll go ahead and turn it over to Mark.
Jason, thanks for the introduction, and thanks to everybody for dialing in. Let's just jump right into the slides here. So we want to talk a little bit about ambulatory strategy and the outpatient migration of cardiovascular care moving forward. We've seen a great migration of ambulatory cases from the 70s, 80s, 90s, and up until today, and really cardiovascular services have lagged behind. So one model we're seeing that seems to have great promise and great traction is this cardiovascular center. Jason referred to it as a hybrid model. Some people call them timeshares or dual entity centers. We're trying to come up with a great name that we can all follow, but I think the cardiovascular center kind of names it. Typically, these are single specialty ASCs combined with an office-based lab. This allows diversification of procedures because there's some limitations in an office-based lab. The surgery center expands the different procedures that can be performed, and it helps one operate as two different sites of service, which enables the access to two different reimbursement models. Because of that, you can maximize the reimbursement changes and mitigate some of the fluctuations we see in CMS's reimbursement year in and year out. These centers operate one day of the week as an OBL, and they designate a different day of the week as a surgery center. My estimates are that there are about 150 to 200 of these centers in operation today in the U.S., and I know there are dozens more under development and still dozens more that are being considered. So is this the wave for the future in ambulatory surgery center growth? Possibly, and it certainly seems like it's a logical migration of cardiovascular procedures from the hospital to the outpatient setting. Just a quick history. ASC started in the 70s. The first center was in Phoenix, Arizona, called Surgery Center. Through the 80s and 90s, Medicare approved more and more procedures every year and developed the payment system that we currently utilize. Today, there are approximately 6,000 surgery centers. Over 3,500 CPT codes are approved, and ophthalmology, ortho, pain, and spine dominate the space. What I find very interesting is less than 5% of all the procedures done in the surgery centers are cardiovascular. So that begs the question, why? Why is cardiovascular lagging behind all these other procedures? That's a conversation for another day, but I think it has a lot to do with the hospital lobby. It has a lot to do with safety and efficacy of procedures, and I think now we're seeing things move forward with PAD moving to the outpatient center, with pacemakers and CRM moving to the outpatient center, and now recently CMS approved coronary diagnostic procedures to be done in the surgery center. If we look at a typical cardiovascular center, the bubbles here indicate procedures that can be done, and some centers are doing all of these, some centers are doing a few of these, and I think through the years this list will ebb and flow and grow with different procedures. So typically at the top there we see endovascular PAD move to the OBL about 12 years ago. Reimbursement is still very healthy. It's a safe procedure, and data comes in that just shows that it's a safe and efficacious procedure to be done in an OBL. Radiology, deep venous and superficial veins. I mentioned here on the bottom, diagnostic coronaries, PCI possibly in 2020. We'll talk about that in a future slide. CRM, depending on in which state you operate, and vascular access are other procedures that are typically done in these cardiovascular centers. So the question is, who should consider a cardiovascular center? I assume that's why many of you are on the call. You either have your own center, you have an OBL, or you're just considering your own ambulatory strategy. But a few things to consider. First of all, case mix and volume and the different specialties that can be included in your center. A really detailed pro forma and analysis should be done of the current case mix and volume, potential future case mix and volume, costs, and how that works into your overall pro forma and return on investment if you're going to enter in an ambulatory strategy. Secondly, your location, the state in which you operate. If you're in a certificate of need state, those are a different set of rules and regulations. Even within the states, there are certain rules and regulations about stenting and device implants that may or may impact your decision to move forward. And then your local ecosystem. I think your group's relationship with the hospital, your relationship with complementary and competitive groups. Every market is different, and there's just local dynamics and politics that really make a difference in whether or not one should open their own center. Lastly, on the slide here, your physical plant. If you have an office-based lab today, is it Medicare certifiable? Does it have sprinklers? Does it have the proper heating, ventilating, and air conditioning? Is it easier to convert or to build a de novo, build a center from scratch? That leads to the question everybody asks, how much will it cost to develop or convert my center? And like a good McGuire Woods attorney, I always say it depends. That was meant to be a little joke at my friends from McGuire Woods, but it just depends. It depends on what you're building, how old your building is, what the physical constraints are. Sometimes remodels can cost nearly as much as a de novo as a building from scratch. So I've listed here the de novo centers cost about $300 to $400 a square foot to build, exclusive of the land. Obviously, costs will be higher in San Francisco than in Kentucky, and maybe more expensive in Miami than central Oklahoma. So that range depends. But a typical center that we see is 2 ORs or 2 Cath labs, about 8,000 square feet. And if you build from scratch, you need about an acre of land. So if you do the math, that's $2 to $4 million to put one of these centers together. Once you add furniture, fixtures, and equipment and some working capital, you're going to be over $3 million. What I like to caution people on or remind people is that you're building an asset. If you have an office-based lab today, no offense, but no one's probably going to buy your building because it's just an office. But a Medicare-certified surgery center is a saleable asset. If in the future, if reimbursement rates go sideways for cardiovascular or your group breaks up and you need to liquidate your $3 million building, there are plenty of buyers. Plastic surgeon, a GI doc, a pain doc, on and on and on. There are lots of options. So this is an investment. You're building a facility that's a Medicare-certified facility that is an asset. When you decide remodel versus infrastructure, how much space do you have in your current space? The extent of the remodel. We've done remodels in Arizona where we had to add a canopy to the front entrance and a generator in the back, and we were done. The buildings were built to Medicare standards. So there's a wide range of how much it will cost to convert your center. And then the other thing to consider is the impact on your current operations. If you have a one-room facility and it needs to shut down for 6 to 8 weeks, that may be a consideration that it's not worth it to convert your center, and you may look to build one from scratch. An estimated project timeline, if you're going to start from scratch, I like to tell folks 12 to 14 months. When we look at a month or two for architectural drawings, a month or two for state permitting, 6 to 8 months or more for construction, a couple of months to get local and state regulations, a couple of months to get deemed status, and then Medicare approval can take up to 6 months. So it is a long process. So if you want to be ready for the anticipated PCI edition in 2020, you've got to start pretty soon. It's already the end of 2018, and with 14 months to build a center, you could theoretically be ready to start in 2020. If you happen to be in a state that's a certificate of need state, that may add another 6 to 8 or sometimes 10 months to get a certificate of need. Really quickly, I'd like to cover the CMS fees for 2019 and just a little reminder of the process. So every July, CMS issues a proposed fee schedule for all CPT codes in all sites of service. From July to November, there's tons of gnashing of teeth from lobbyists, special interest groups, industry, who go to CMS in Washington and say, why did my rate get decreased, or why didn't our rate get increased? There's a lot of back and forth, and then on November 1, the final fee schedule is released. That just happened a couple weeks ago. That fee goes into effect the 1st of next year, and then in July of next year, it happens all over again. So that's why opening a dual entity or a hybrid model allows you the flexibility. If rates go up in one center and down in the other site of service, you've got the flexibility to combat those big swings. So the 2019 final fees for 2019 were really good for our world, for the cardiovascular and the vascular world. So specifically, if we look at cardiology, diagnostic coronary caths were added, and that's a big step most people think toward PCI. And EP implant rates basically stayed the same with the exception of loop recorders, which dramatically went up. There was a 43% increase in loop recorder implant rates in an ASC. So those two types of procedures, diagnostic coronary caths and EP implants, can only be done in an ASC and be paid for by Medicare. PAD can be done in both sites of service, OBL or ASC, but it pays better in the OBL. And rates went up fairly dramatically in the OBL for 2019, even though the proposed fee was for a big reduction. So a big change of events there, which was great for anybody doing PAD work in an OBL. The last group I have there are vascular access, so fistula maintenance, and even fistula creation for that matter. But fistula maintenance in 2017 took a dramatic cut in the office-based lab setting, which shifted many centers to convert to an ASC. ASC rates were proposed to take a big cut for 2019, and that was rolled back. They did not take the big cut that was proposed in July. So if you do vascular access cases, it pays much more to do them in an ASC rather than an OBL, and the good news is the rates are not going to be cut back for 2019. So these three different specialties, some can be done in one center, some can be done in another, some are paid better in one site of service, others are paid better in the other site of service. These illustrate to me the benefit of the dual entity, the hybrid center, and that you can toggle back and forth and take advantage of where they pay the best. Finally, the slide, for those of you in cardiology are familiar with these CPT codes. These are the 12 diagnostic coronary cath codes that were added to 2019 in the surgery center. The reimbursement is about $1,400. The pro fee is about $335 on a case that doesn't take too long, and the supply costs are pretty minimal. I'm not sure how much migration we will see from the hospital to the surgery center in 19. We have some centers that are interested in moving cases. I think the jury is out, and we'll know in the next 6 to 12 months how many of these cases migrate to the surgery center. But most would agree this is foreshadowing. This is the first step in bringing PCI to the ambulatory setting. So that's what I had to cover today, just to kind of lay the baseline on what these centers look like and how reimbursement is changing and ever evolving, specifically for 2019. I'll hand the slide deck back over to Jason to dig into the legal issues of opening your own center.
Thanks, Mark. Okay, so we'll now turn our attention to discussing some of the legal considerations for setting up an OBL or a hybrid, with a particular focus mainly on the OBL structure. A number of folks on the call are far more familiar with the ASC structure, and if you have questions about ASC investment in particular, we're happy to follow up with you directly. So this will be more OBL focused. Depending upon the identity of the investors, whether you're dealing with physicians or hospitals or management companies or even private equity, the short and long-term investment goals of the parties and also the laws of the states in which a facility is located, there are generally two key different organizational structures for these types of entities. One that involves direct investment in a practice-based entity, and a second organizational structure, which is a management services organization, PC structure, or an MSO-PC structure that will be discussed in far greater detail later in this presentation. All of these statutes, both federal and state, should be consulted when organizing an OBL or a hybrid entity through investment. Additionally, the presentation will not focus on the laws and the safe harbors applicable to ASCs. As we mentioned, this will be more focused on the OBL side of the house. So as you take a look at the list of statutes on the prior slide, what's the government principally concerned about? And the answer is kickbacks to physicians, and more fundamentally, that medical decision-making should not be tainted by physicians' financial considerations. All of these fraud and abuse laws have the same fundamental goal of attempting to preserve independent and unbiased physician medical judgment. So keep that in mind as we're going through some of the slides and structures, and you can think about whether the laws accomplish that goal. I'll turn it over to Jake.
Thanks, Jason. So coming off Mark's upbeat, presentation about some of the opportunities that are out there, I don't mean to be too big of a wet blanket here, but these are very important considerations that you always want to keep in the back of your mind. I'm going to cover, broadly speaking, the federal anti-kickback statute and the federal prohibition on self-referrals, which is known as the Stark Law. And one thing to keep in mind, and Jason kind of mentioned this is just touching on sort of the basics, and each fact pattern, each organizational structure, each set of circumstances should always be separately evaluated in detail based on the facts and circumstances at issue, because a lot of these things can get pretty thorny, especially when we get into the Stark Law, which I'll mention later is a strict liability statute, and there's not really a risk spectrum that you'll find with some of the other fraud and abuse regulations. So first, the anti-kickback statute. So generally speaking, this prohibits the knowing or willful solicitation, receipt, offer, or payment of any remuneration, which essentially means anything of value, in return for or to induce the referral, arrangement, or recommendation of Medicare or Medicaid business, among other federal healthcare programs. The thing to keep in mind when you're dealing with the anti-kickback statute is you want to always remember that it's an intent-based statute. So in order to establish a violation, the government has to prove that the parties acted with the intent to offer something of value in exchange for referrals. So how is that determined? What do they look to when they try to find out whether the requisite level of intent was there? So the common things that they'll look at is if an investigation is underway, they'll look at things like emails that are exchanged between the principals involved or the business folks, text messages are frequently used, correspondence. Then they'll also look at the joint venture documents, the organizational documents, and then any other circumstantial evidence that you can think of will be unearthed in connection with one of these investigations to try to find out whether or not the parties acted with the intent to violate the statute. The good news is the OIG, or the Federal Office of Inspector General, has promulgated safe harbor regulations that are very frequently used when structuring cath labs or OBL arrangements. And we put up here on the screen some of the key safe harbors that are usually at play. The management services and personal services safe harbor, the small investment safe harbor, and the investment in group practices safe harbor are all ones that we'll talk about in greater detail in a second here. We've also identified there the ASC safe harbor, which would apply obviously if you're an ASC, but wouldn't apply if you're not an ASC. So that has its own separate elements that we here can advise you on. We're not going to talk about it in great detail here, but if you are looking at an ASC model or you already have one in the works, we can work through that with you as well. So the safe harbors are one thing to keep in mind when you're thinking about safe harbors is that structuring a cath lab in many cases could be difficult to make sure that it fits squarely within a safe harbor. But again, because the anti-kickback statute is intent-based, because something doesn't comply with the safe harbor does not mean that it's illegal. What the safe harbor does is each and every element of the safe harbor is satisfied, it will protect the arrangement from liability under the anti-kickback statute and can be raised as a defense if there is a prosecution. So moving on, I want to touch base about sort of what the big stick is or what the government looks at the anti-kickback statute to be in its view as a mechanism to enforce fraud and abuse laws. So this isn't meant to scare anybody, but you should understand what you're dealing with and the potential liability that you could face. So a violation is punishable by up to 10 years in prison, and the fines can be up to $100,000 or both. In addition, there's also parallel criminal and civil investigations being opened, all the time, because anti-kickback statute violations can also result in civil and administrative penalties, as well as exclusion from participation in all federal health care programs. Civil monetary penalties in particular can be up to $74,000 and change per kickback and 3 times the amount of illegal remuneration received. There is no private right of action under the anti-kickback statute, so you can't be sued by a disgruntled employee for an anti-kickback statute violation in and of itself. But it's important to remember that under the False Claims Act, it does have whistleblower provisions that allows those who identify false claims being submitted by an organization to bring a claim, and they get to collect 1/3 of the award if there is one. And they can use the anti-kickback statute as a basis for their allegations in a QTAM whistleblower action under the False Claims Act. So it's sort of a way around the bar on private rights of action under the anti-kickback statute. And the other thing to keep in mind is that the corporate and the organizational form that is used can also provide additional liability protection for the entity, but also the government is increasingly looking to pierce the corporate veil, as they say, to go after individuals involved in fraudulent schemes under the anti-kickback statute. And we wanted to highlight here, in September 2015, the then U.S. Deputy Attorney General Sally Yates issued what's known in the industry as the Yates Memo, which was followed very closely because it, for the first time, came out and explicitly said that the DOJ would begin to more aggressively pursue individuals involved in potential fraud and abuse. It also said that corporate fraud and abuse cases should not be resolved without addressing individual responsibility. So all the U.S. attorneys in the country were instructed to look at that specifically. And since then, we've seen a significant uptick in the individual enforcement actions that have occurred in the wake of the Yates Memo. And then, another thing to keep in mind is we see sort of with the Trump administration, even with significant budget cuts across the government, the budget to enforce and prosecute fraud and abuse related claims has actually increased. So, this isn't stopping anytime soon. So against that backdrop, you always want to consider the spectrum of risk that you face because, again, we are dealing with something that is an intent-based statute, and you can really kind of take the risk that your organization faces after working with your lawyers to determine what that is and put that into your business plan and determine how you want to proceed. So now I just want to touch on, I'm not going to go through the safe harbors in great detail, but I want to just make sure that everyone has a chance to see what the elements are, and then I'll mention a few high-level takeaways. So this is the Personal Services and Management Contract Safe Harbor. This is what you would use to protect things like MDAs, medical director agreements, administrative services agreements that may be in place between an MSO, a management organization, and a physician entity to manage an OBL or a cath lab. And then any other agreement where you've got a referral source involved with that receiving some sort of compensation for management or personal services provided to the entity that furnishes the services. The key elements here are the fifth one down, that the compensation be set in advance and consistent with fair market value. We oftentimes recommend that our clients obtain independent fair market valuation assessments so that they know they've got a range of figures to work with, so that they have a strong defense in case anybody challenges whether or not something is fair market value. And then the other one I wanted to note here is the last one, that the aggregate services contracted for cannot exceed those which are reasonably necessary to accomplish the commercially reasonable business purpose. So you can't pay a physician who would demand more money for services provided within his or her specialty more money to do something that an administrative person could do. It's got to be done in commercially reasonable terms in each circumstance. Flipping to the next safe harbor, we want to touch on the small investment company safe harbor. So this is what you would use and look to protect your investment in the cath lab entity itself, or a holding company that may hold an interest in the cath lab indirectly. And this applies to passive and active investors that are either passive or active, meaning they're referral sources and they don't actually perform services at the lab, or they're active in that they are referral sources and also actually perform those services there. And the government is really concerned about passive investment because, as you can imagine, they don't like it when physicians can refer patients to an ancillary services provider for services they don't have to perform, and then they reap the benefit from that financially. So a couple key elements here is the first one, which requires that no more than 40% of the value of the investment interests are held by those investors who are in a position to make or influence referrals to the entity. And then flipping to the next 40% test, is what we call it, is that no more than 40% of the entity's gross revenue related to the furnishing of healthcare items or services in the previous 12 months comes from referrals or business generated from investors. That's the third bullet down on this slide. And some of you may be looking at that and thinking, we get 100% of our business from physician investors, or some figure well above 40%. And we just want to, relay that that's not uncommon. We do see that in the industry quite frequently. And frankly, there's just certain service lines that the government does not take a particular interest in when it comes to looking at whether or not a high volume of business is generated from referral sources. And we would put the cath labs in that category. That said, you're not going to be able to satisfy the safe harbor. So when we're working outside the safe harbor, there's always, again, that spectrum of risk you need to look at, in that you're not going to be immunized from ultimate liability under the Anti-Kickback statute. So what we always recommend to clients is, as a prophylactic step, try to comply with as many of the other elements of the safe harbor as you possibly can to, again, drive down that risk and minimize the chances of a prosecution. And we can kind of talk through that with folks separately offline if you have questions about that. And then the last safe harbor we want to touch on is the investment in group practices safe harbor. So this is sort of a limited safe harbor that a lot of folks won't be able to utilize unless you're truly operating the cath lab or the OBL within the context of your group practice. Because what this does is it excludes from the definition of remuneration any payment such as a dividend or interest income made to a solo or group practitioner investing in his or her own group practice if the four standards on this slide are met. And all of these relate to, again, a closely held entity that's strictly tied to a group practice. So you've got an OBL that operates, under the same tax ID as your group practice. This may be an option for you, but it will be of limited use when you're dealing with outside investors or under the MSO-PC model that Tim will talk about in a little bit. Okay, shifting gears here, we'll talk briefly about the Stark Law. So the Stark Law, subject to certain exceptions, prohibits a physician from referring a Medicare or Medicaid patient for the furnishing of designated health services, a defined term, to an entity with which that physician or a family member has a direct or indirect financial relationship. Key here, intent is irrelevant. So unlike the anti-kickback statute, Stark liability, the Stark law is a strict liability statute. So you don't have, unfortunately, that large spectrum of risk that you can look at. You really need to drill down on what is your arrangement, what services are you providing, and can we fit within an exception? There's various exceptions to the Stark law for a lot of common business arrangements, but each element must be met. So you don't want to just kind of skirt around the edges. You really need to dig in and make sure that you're protected. Penalties can be severe. We've listed them up here. There's an overpayment refund obligation. If you don't make that refund, then there's potential False Claims Act liability. So the first step to looking at this risk is to look at your CPT codes. CMS publishes a laundry list of CPT codes that are considered DHS. A lot of diagnostic imaging codes are on there. And if you identify any DHS that you perform at your facility, you want to find out what exception applies and try to work within that exception. The most common one that will apply is the in-office ancillary services exception, which we've summarized on this slide. This is intended to protect referrals for DHS within the context of a group practice and that are performed, quote unquote, within the office. So there's three requirements that you need to satisfy. There's a supervision requirement, which relates to, who is either providing the service or supervising the service. That's got to be done within the group practice. And again, these are very nuanced definitions, so this is a super high-level summary here, but you really do need to drill down into each one of these tests. The next one is the location requirement. The DHS must be furnished in the same building where the practice provides services or a centralized building. And then billing, the DHS must be billed by either the physician performing services, the group practice, using a billing number assigned to the group practice, or a wholly owned subsidiary of the group practice. And I just mentioned group practice several times there, and that's because that's a key definition when it comes to thinking about Stark. To qualify as a group practice as a threshold matter, which kind of gets you into the world of satisfying the exception for in-office ancillary services, you have to establish that you're operating a single legal entity, at least 2 physicians. Each physician must furnish substantially the full range of patient care services through the group practice, and with certain exceptions, substantially all of the services of the physicians who are within the group practice must be furnished through the group and billed under the group's billing number. So it's really hard to kind of get through all the considerations when you're dealing with Stark in a few minutes here. So again, feel free to reach out to us. These issues can be thorny, but it's always something you need to consider. All right, with that, I'm going to turn it over to Tim, who's going to talk about the legal structures.
Thanks, Jake. And when we talk about legal structures, this slide is probably familiar to many of you, and that's intentional. At the top, Mark talked about kind of the move and new CPT codes in the ASC space, and that's exciting in large part because this model, which you may have seen many times before when it comes to surgical centers or other joint ventures like imaging, can start to be used in more and more cases for more and more procedures. This is a very standard model. Of course, you can replace the box with national company with other things like investors or hospitals. We see some hospital joint ventures out there forming ASCs or other types of Cath arrangements for kind of the office-based lab space. So this shouldn't just be read as an ASC slide, but of course this works for ASCs and is very typical. We are seeing other joint venture type models for, if allowed by state legal structure, which we'll talk about in just a second, for the office-based lab side, the practice side as well. But yes, for surgery centers, definitely. We're also seeing things similar to this, and many of you have probably dealt with this over the last 5 years if you've been in this space. Hospital co-management relationships, certain under arrangement relationships that hospitals have as well. So there are some variations on this, but this is kind of the default model, and in a perfect world, you'd use it kind of across the board. Unfortunately, states don't necessarily allow us to do that across the board. because of the corporate practice of medicine. And, you know, some of us are going to say it's archaic. You know, I certainly probably would say that. That said, some states care a lot. Kind of the four corners of the United States, California, New York, Texas, and North Carolina, boy, do they care about corporate practice and making sure doctors own the medical practice. So when we're talking about kind of the hybrid that Mark talked about earlier, and then I'll talk about kind of as we talk about structuring for the next couple slides, we're talking about that practice side, things that maybe you'd get a better reimbursement rate in the office than in the surgery center. Or, you know, Mark put up the 10 to 12 new codes that are finally going to be done in a surgery center. You know, they historically couldn't be done in a surgery center, but some of them could be done in an office, and there are certainly codes out there like that. So you look at a hybrid to do both, and if you're in the hybrid area, that pretty nice JV chart that I had on the last slide might not work. And states really vary on that, but across the country, we're still seeing states with kind of corporate practice restrictions. That doesn't mean you're stuck, and we're going to talk about the MSO-PC model in a second, but states vary here as well. So we've kind of pieced this into three columns of what things have to be at the practice, what the physicians have to choose, what things can be joint decisions, and which things kind of the manager typically has. You have that in front of you. I won't necessarily read all of them. But note, this is very state specific. So in California, for instance, I probably would not say that it's an MSO decision about office space and expansion. Office space, and you know, if you're going to have a second OBL, or if we need a second procedure room, that's really a choice that the physician has to make in California, and the management company can then build out the space. But this is a very typical breakdown, and certainly would work in a state like Michigan, where the Attorney General has only gone after physician groups. Actually, now the former Attorney General, I believe, he was running for governor. He only went after physician groups over the last decade if they were abortion providers. So it had nothing to do with corporate practice of medicine and had to do with other types of politics. That's the problem with archaic law, but it's the function we have to be in. We also face fee-splitting questions. For instance, in Illinois, a management fee cannot be percentage-based, or it cannot be all revenue. A lot of states have that prohibition against all revenue coming out of a practice, California, Texas, others. And so if that's the case, you have to look at other things like a flat model or a cost of services plus a markup. So state fee splitting laws also come into play. And I'm actually going to skip this next slide, but just to note so that we can start to get into the pretty diagrams here of legal structuring too. You get to a situation here, and this is what I was talking about with the fee, which is the PC and the management company. We'll talk about that on the next slide. For the office-based lab, the PC brings in all the revenue. It has certain expenses, the clinical staff, the clinical benefits, drugs, professional liability insurance, things of that nature, and a management fee or a services fee. And that leaves whatever operating income that will be here at the practice. The management fee then goes over to the management company. The management company could be the exact same joint venture partners as in structuring one. That's a very popular concept when you have a surgery center OBL hybrid, which is you have the same investors in the surgery center also invest in this management company that'll be managing the OBL side of the business. There's its expenses, and then it has its operating income. And different people will structure this fee differently to see how much of the economics will be at the different practices or at the management company. And then this all gets baked in together, the MSO-PC model with this diagram. And one thing to say is we've really tried to simplify these slides. So you may overlay legal structure 2 with legal structure 1, and the management service organization may be synonymous with the ASC and have the same investors, kind of a joint venture partnership. There might be more than one professional entity involved. A lot of excitement around ASCs is you don't have to just do it within a group necessarily. You can have multiple physicians or physician groups. Well, people want to mirror that surgery center model with OBLs, office-based labs as well. And so the MSO model sometimes allows you to do that, and to Jake's point, you have to worry about things like the in-office ancillary services exception for each group. But sometimes that can be done and kind of have everyone invest through the management company or a joint venture without all coming together. So there are a lot of variations on this. But the key takeaway here, especially as you get to a hybrid type model, if you go there with both a surgery center and an OBL, is how does all the ownership work together? Can you hit safe harbors? Are there exceptions that are relevant? And then do that within the corporate practice of medicine restrictions, especially on the OBL side. I'm going to turn it over to Jason for these last probably 5 to 10 minutes before we take questions. He's going to talk about these considerations a little bit more, but we, of course, would always welcome the chance to talk to you this and structure this with you.
Thanks, Tim. Okay, so just digging in one level deeper on the MSO-PC model and the Administrative Services Agreement, and just to back up, as you saw on the previous slide, the key relationship between the PC or the professional corporation and the MSO is this administrative services fee. And you are structuring that administrative services fee, as Jake discussed, in compliance with the Management Services Safe Harbor. So when you're doing that, we want to mention that many cardiac cath labs and OBLs, going back to what Jake said about DHS and Stark law, let me touch on that briefly before we move on. Many cath labs and OBLs wish to provide certain complex imaging and lab services that may be considered DHS or designated health services under the Stark law. A cath lab or OBL, as Jake said, must satisfy an exception, and we talked a little bit about the IOAS, the in-office ancillary services exception. But it's important to understand when you're looking to develop a pro forma that it can be difficult sometimes to satisfy the Stark law in-office ancillary services exception, depending upon who's involved in the structure that's used. So what you do is you take a look at your CPT code list up front when you're generating your pro forma, to see whether you can provide those certain CPT codes in compliance with an office ancillary services exception or some other applicable exception. And if not, then the next question is, can you perform some of those CPT codes in an ASC if you're using a hybrid model? And if you can't, if the answer again is no on the OBL and no on the ASC, then you need to adapt your pro forma, which could impact not only the types of procedures, but whether you're a go no go on the project. So of all the elements required to satisfy the AKS management company safe harbor, and I want you to keep in mind the frame of reference of we're focusing in on the relationship between the PC and the MSO now in this MSO-PC structure. The most important element is ensuring that the fair market value of the fee between the management company and the PC is consistent with fair market value. And so it wouldn't be a legal presentation if we didn't put up the definition of fair market value somewhere here. So here's the definition that evaluation company will typically take into account. It's the Stark Law definition, which applies equally to both Stark Law and AKS considerations. And so, as Jake mentioned, in order to ensure that the arrangement is consistent with FMV and commercial reasonableness standards, we typically encourage clients to obtain a valuation of the management fee from an independent valuation company, and also to have a detailed discussion with the valuation company about what services will be provided by the MSO and what business and legal risks the management company will assume under the arrangement. And there are really two different types of management services arrangement. There's the typical management services arrangement that you often see in an ASC context where, if you can do it in accordance with state law, you charge, some fair market value percentage of net revenue. And this type of management arrangement within the MSO-PC model, which, oftentimes the management fees are substantially higher in an MSO-PC model. And the reason why is because the MSO in an MSO-PC model is taking substantially more risk and is oftentimes providing substantially more services than in a typical management fee. But nonetheless, it's as has been said elsewhere, it's important to go out and get a valuation to ensure that this arrangement is consistent with fair market value. So a few other considerations in the MSO-PC model. It's important to understand that the MSO will likely be a HIPAA business associate and should implement a HIPAA compliance plan and conduct regular security audits. As Tim mentioned, there's some state fee splitting and corporate practice of medicine laws that prohibit a management company from engaging in certain practices. Among those is marketing on behalf of the professional corporation and contracting with payers and manufacturers on behalf of the PC. From state to state, there's a variety of differences in the restrictions, but those are a couple of common ones in a number of states. Finally, we want to mention that an increasing number of states require physicians to notify a patient about a healthcare entity in which they have a financial or ownership interest. So we typically recommend implementing an ownership disclosure form that is handed out to patients in the office, at least as a best practice, and in some states is consistent with requirements of law. So we're coming to an end, and we'll have about 10 minutes here, I think, for questions. There are a bunch of state laws in addition to corporate practice of medicine and state fee splitting statutes that you need to keep in mind. Almost all states at this point have statutes limiting or at least preventing physicians who have an ownership interest in the Cath lab or OBL from making referrals unless a safe harbor can be met or closely satisfied. And many states have elected to mirror the federal anti-kickback statute's self-referral restrictions, but some states have statutes that are far more restrictive, so it's important to take a look at your state regs. Unfortunately, in many states, the biggest challenge is that the answers to those questions may not be clear, depending upon the degree of enforcement that's gone on in a particular state or the clarity of the law. So oftentimes, we'll take a look at the state law, we'll research secondary sources, but at the end of the day, when you're looking at these states that have had minimal enforcement, and there's a great variety there, there's just potentially some level of inherent risk that states decide that, hey, something's happened and now they want to, they want to enforce some of the things that they have on the books. State certificate of need laws, that was briefly touched on. We'll say this, that only a limited number of states have CONs applicable to office-based labs or cardiac cath labs, but a number of states have CON requirements related to the development of an ASC. So if you're looking at a hybrid model, it may come into play on the ASC side of the house. Obtaining a CON can add significant additional expense and lead time, as Mark touched on, to the development process. So it's important to evaluate this early and to engage an experienced local CON consultant if a CON is required. It's also important to understand whether competitors will have an opportunity to object to your CON application, since such a right generally adds additional time and potential expense to the process and also may inject some uncertainty into the process about whether or not you'll even be able to obtain a CON in those types of states. So again, it's good to know that up front. And then additionally, there are state-specific licensure requirements. And of everything listed here, I think it's important to note that a number of states have older laws on the books requiring cardiac procedures to only be performed in a hospital setting. This is an area of law that is changing rapidly, however. Some states are significantly loosening up these rules and making it more permissive, consistent with federal law, while in some states it's actually becoming more difficult to perform these office-based procedures due to lobbying efforts of different types of providers. So this is an area of development in the law, and we'll just have to follow it. These types of restrictions on what types of surgeries can be performed in an office-based setting can often be found in CON laws, licensure laws, medical board guidance, and state anesthesia laws and statutes. So it's important to take a look at a number of different sources. And lastly, we've seen a number of Medicare administrative contractors or MACs around the country either become more involved or less involved in what types of surgical services can be provided in an office-based setting. And a number of these MACs have issued LCDs or local coverage determinations. Novitas was a recent one that discussed a number of different office-based procedures, and they actually have a pending LCD on the books that may or may not go into effect, preventing certain types of surgical services to be performed in an office-based lab. So stay tuned on that. So with that, we appreciate everyone's time, and we've got about 10 minutes, and we've seen some of your questions, but if you've got some questions, please feel free to go ahead and add them to the Q&A tab at the bottom of your screen. But we'll go ahead and try and answer, some of these questions. If we don't get to your questions, please note that we'll go ahead and follow up with you offline as well. Mark, of the ones that you've been able to read, are there any that you want to talk about first while we're getting up to speed?
Well, Jason, the question I see that is pretty common, two of them. One is, have you seen any JVs with physician practices and hospitals for OBLs? I think there's a lot of misinformation out there about how that can work. Can you speak to that type of structure?
Yeah. So, Mark, I think we've had a fair number of questions about can hospitals and health systems invest in physician practice. Do you want to do this? And there seems to be a growing amount of interest. And I think the answer is, depending upon if you're dealing with a for-profit or not-for-profit institution and the state that you're located in, what you would do, if you can do it, is to use an MSO-PC model and to set up a management services organization where the physicians in the practice and the health system are together owners in the MSO to essentially become owners in the PC. So, yeah, there is a structure to do it, but there are a number of additional considerations baked into it.
Another question that we get quite a lot, and I think you've seen it here as well, is, for cardiology practices that have more of generalists and then has, more of the interventionalists, how should they handle it? And what if the whole group wants to be involved? And that's a tricky issue. It's one that the government is very concerned about when non-specialists own in and refer to a center, and the OBL sort of takes that up a notch beyond just surgery centers. If the group is consistent and kind of is a unified whole and sort of shares revenue collectively and owns the units together, often you can navigate both state and federal law to kind of, as a group, protect the cohesion and the working together of the specialists and the generalists. The problem becomes when groups tend to try to slice and dice that to give an eat-what-you-kill model, but then also reward those that are referring by giving ownership, and kind of they start splitting that up, then your risk under things like the federal kickback statute becomes very challenging. And so to one of the questions that we received, how should the group be thinking of that with kind of the interventionalists, cardiologists, with, maybe those that won't be using the OBL but will be seeing patients? They should think about their own culture, and if everyone's going to participate and own in that collectively, probably okay. If we're just going to do that to try to lock in some of your generalists, and I don't mean that in a demeaning way, especially cardiologists that know a lot, but you just need to be very careful, and it gets pretty specific of how each culture is set up. I think there's also been some questions specifically on kind of the hybrid model. Mark, you can probably speak to this a little bit as well. But under federal law, under Medicare law, to use a surgery center, you can rent space or lease your space as a surgery center to a group practice, or in this case, an office-based lab, as long as there is temporal or spatial separation, and state law allows it. Not all states allow a surgery center or a licensed facility to share space with an OBL, and so you have to see if state law will allow it. But if state law allows it, federal law will let you operate a surgery center, effectively shut that surgery down in the afternoon, or let's say Monday morning is a day that your current orthopedic surgeons at a surgery center aren't using it, and that gives you enough time to schedule some Cath procedures in the surgery center that have now been blessed by CMS. You can shut down the surgery center. I apologize. You do some procedures that can't be done in the surgery center. You shut down the surgery center, you change your signage, you keep separate medical records, and you can rent that space to a medical practice to be used as an office-based lab.
So we have a question here. Is there a change in the hybrid center from ASC days to OBL days in terms of the staffing? And so, Mark, I think that this is both a legal component as well as an operational component. On the legal side of the house, you're getting in an ASC a technical fee that you're not getting on the OBL side of the house. So oftentimes, the justification for that that additional technical component is you have different and higher staffing costs. So I think the answer is, yeah, oftentimes there are different staffing ratios and staffing systems that are put in place when you're running on an ASC day versus an OBL day. But Mark, do you have thoughts on that one?
Yeah, the short answer to that question is it's the same staff day in and day out. We need different HR files, different offer letters, different employment agreements for most of the staff, but it's the same group day in and day out. I think it was Tim that was just mentioning the possibility of splitting a day, half the day OBL, half the day ASC. Yes, that's possible to do, but practically that seems to be challenging if cases go too long in the morning and bump the afternoon cases, or if patients don't show up. It can be really tricky to try to split a day in half between the two. We typically see centers doing one full day as a surgery center and one full day as an office-based lab.
Okay, we recognize that there are a few questions that we haven't been able to get to. Mark, is there one more here that you want to address? Otherwise, I think what we'll plan to do, folks, is to follow up with you if we didn't get to your question. But otherwise, we really appreciate everyone spending some time with us today, and we hope that you found the presentation to be helpful. Thank you.
Great. Thank you.